Hello, hola, ni hao, salut, namaste, everyone, wherever in the world you're listening to this, and welcome to 100 Sum Game, a podcast where we discuss negotiation, persuasion, and influence. Join me as I interview master negotiators from a new industry each episode and get inspired to get the best outcome for yourself while creating value for your counterpart. My name is Adele. I'm a recent economics and psychology grad with experience in finance and marketing, and I'm fascinated by the power of negotiation to change your life and career. Whether you're an early or seasoned professional looking to accelerate your career, negotiate your value, and tactfully handle conflicts, or simply a curious individual aiming to level up your soft skills, leave your shoes and missed opportunities at the door, and let's get started. Hello, and welcome to yet another episode of 100 Sum Game. This is going to be an interesting episode because today I have a law professional with me, Juliana Saxberg. She has been in the field for more than 20 years. She has her own firm now, and we're probably going to demystify all your suits fascinations. As you all know, negotiating and persuading in law is very important. Hi, Juliana. Welcome to my podcast.
Hi, thanks. I'm honored to be here. Thank you.
Awesome. So let's start with getting to know more about you.
Great. Well, I'm a first-generation lawyer, and I went to law school in the late 20th century. I went to the University of Toronto. And then after that, I kind of did a bunch of different things. I graduated in 2001. I was called to the bar first in 2002 in Ontario, and later in Saskatchewan in 2007. And over the years, I've worked as a lawyer in private practice, and I've worked as in-house counsel. And as you mentioned, most recently, I'm coming up on the third year of having my own firm called Artia, which is really focused on helping organizations with dispute resolution for workplace governance. That's really kind of my thing these days.
Yep. So going off of that, how does negotiation interactions look like in your specific law field, so employment and workplace law?
Well, I think I've done a ton of negotiations in different kind of situations. So the number one way that I engage in negotiations is usually to resolve claims, whether I'm acting for the claimant or the respondent. Usually something has happened that has brought, someone to file a lawsuit, and we get into mediation at the beginning with the initiation of a demand letter. And then sometimes we also go through structured mediations in the context of a court-ordered mediation or mediation assisted by tribunals. But a lot of the mediation, or I guess the negotiation that I do day by day is, with other counsel, with organizations, and with claimants trying to bring things to resolve so people can get on with their lives.
That's very cool. So Juliana, you're known to be a good negotiator, a really good one in her field. So what is your negotiation tactics? What is your negotiation style, and why do you think it brought success to you?
Thanks. That's a really great question. I'm always looking for a mediated or negotiated outcome to every single claim. I think that that's where I start. So that's really important, number one, to manage everybody's expectations. I've had debates with other lawyers about whether or not we actually have an ethical obligation under our code of conduct to promote settlements. And I think that we do. My reading of our code of conduct says that we will promote settlements and discourage suits that are not meritorious. Especially in labor and employment, most of our cases are what I call, I'm sorry, this is probably not very flattering, but nuisance cases, meaning that the cost of a payout for liability purposes is generally going to be a lot less, sometimes by a factor of 5 or 10-fold, than the cost of defending the claim. And so right away, that informs the negotiation dynamics. So if I'm acting for a claimant, right away, I'm always looking for ways to increase our leverage, because there's also usually disparate bargaining power, right? So the claimant would probably be an individual with modest means compared to the respondent that's likely going to be a company or an entity that has maybe a little bit better resourcing, although I know a lot of the people I work with are also, they're working in small to medium enterprises. Not everybody works for the big companies or the government, right? So sometimes there's a range in terms of the bargaining power, but as a general rule, claimants come to the table with less bargaining power. usually starting with a claimant, I'm looking for ways to increase our leverage and to put together a negotiation position that reflects an outcome that my claimant is going to be able to accept and feel okay about and move on from. Although it isn't 100% the outcome that informs that feeling of being like, I'm satisfied and I can walk away with this resolution. I think there's a lot that we can do in terms of process too, to make people feel better about the outcomes of negotiations, right? So it's not just that we design a resolution at the get-go that we think is going to be fair or adequate. We pay attention to the way that they're included in the process throughout the process, because I find that if people do have an opportunity to participate and they do feel like they've been heard, often they're more prepared to accept a settlement that maybe isn't everything they dreamed of, right? So,
Right. Another follow-up I have on that, which was a question that was frequently asked, how do you negotiate contracts?
Oh, yeah, that's a good one. Well, for contracts, usually, I love this question. Often what happens is I would represent a party who brings me a contract that maybe was drafted by somebody else, right? So my approach to contracting is usually completely different from what other people are bringing me. My contracts I design to be useful tools, not only for allocating and shielding liability, but also to govern the relationship. And I think that if contracts are going to be effective relationship governance tools, then they need to be something that people actually read, right? And so I start with a simplified plain language contract, if at all possible, and I make sure that everybody understands the terms. I think that if we did that, like 80% or maybe 90% of disputes might be avoided, number one, because I can't tell you how many times we hear, I didn't read it, I just clicked accept or whatever, right? So I think it starts with really understanding the purpose of the contract, but also the content of the contract, and rejecting contracts that are full of legalese or contracts that we cannot understand, right? Because those, I think, generate a lot of work for lawyers, but they also can be a minefield for disputes when it comes down to needing to resolve disputes within a contract relationship. Again, if we can access tools like shared values or rules about communication and accountability, they provide benchmarks for negotiation that I find are really essential to build a resolve, right? You'll hear me talking about benchmarking a lot. One thing I always tell my clients or anyone who asks me, like, how do I put together a good negotiation position? Like I have to do a mediation brief or whatever. I'll say, number one is to benchmark everything that you're asking for. And that means that you provide a rationale for every single position that you're taking. And that can be, if you're looking for a specific salary figure, you can access benchmarking data for salary for the position. You can access that data in Canada through Statistics Canada. Sometimes we'll say, yeah, we know this language about workmanship is the industry standard. However, we're not interested in using that standard because it's too difficult to apply and it leads to too many disputes when we're working within the contracts. I think if people see your position as reasonable, and to me, like, reasonable is a really difficult term for any law student or lawyer to define. I simply say something is reasonable if you can provide reasons, right? If you want your position to look reasonable, you need to be prepared to provide reasons, even though at the end of the day, we all know when it gets to negotiation time, a lot of times the numbers we're choosing are arbitrary,
Yeah, thanks for sharing that. Okay, so let's move into some psychology. Can you tell us about the influence of psychology in convincing jury? And with that, the influence of body language or storytelling? And how do you convince the jury by leveraging those soft skills, if you will?
Yeah, I don't know if I would call it psychology, but I've always thought of it as theater. Okay.
Okay.
And I think when you're going into, if it's a court case or a mediation or, even just a meeting with the other party, a lot of people make the error of starting out, what I call starting out on the back foot, right? So maybe you're the respondent and you feel like you're coming in to answer an attack. But the fact is, the first time you show up for any kind of dispute or you show up for any kind of exchange, you have the opportunity to define your position and to define the issues in a way that you're never going to have again. You know what I mean? It is really important, I think, to take the time to look at, whatever the reactive position is and then say, is this really the position that puts our best foot forward? Because a key tip that I would like people to remember when you're doing negotiations or you're engaging in any of this kind of theater is that you don't have to necessarily answer the questions that are put to you, except in cross-examination, okay? That's when you do. But when you're framing the pleading or you're framing your demand letter or you're framing, your presentation, it's a great idea to really focus on what you think is the important issue and really try to attach story to it in narrative, because people do find narratives compelling and they do, I think, really connect with individual human actors to the extent that we can really make them human. And so that's another thing I always want to do when I'm preparing for a case or for a mediation, is really find a way to humanize the parties to each other and to the trier of fact. It's easy not to dismiss an employee as just like a bad actor, right? Whatever it is, but to remember that this is a human being that exists in a context and has, a lot of different angles, right?
Mm-hmm. Honestly, this reminds me of the Depp versus Heard case, because I know later on the lawyers came and they were explaining their strategies, and they said that, okay, we tried to position Depp as a human, as like that vulnerable, likable being. So that's why they brought his sister, they brought folks from his past to paint that picture to jury.
Yeah, I think that's a really extreme example of how, you can really manipulate theater, you can really manipulate public opinion, especially in certain courts in the United States, that maybe is going to tell a different story than, to use the example of Depp versus Heard, the English court, the trial court and the UK Court of Appeal both sided with Amber Heard's version of the story. And this all happened well before the trial that people think of, right? So this happened over in the UK, and Amber Heard wasn't even really a party because Depp had sued the newspaper there. As part of their decision-making, the House of Lords did go ahead and review all of the facts, and they did make findings of fact based on Amber Heard's testimony and the evidence that are just not consistent with what the United States court did. And I think that that's not only interesting, it's highly problematic, because I think there's a lot of documentation of how the proceedings in the United States trial were badly manipulated through social media, right? So,
yeah.
An interesting thing that I read, though, is that recently people are starting to change their opinion about what happened. Now,
Interesting.
Yeah, the deluge of social media has quieted, and so we're not constantly faced with all of these messages from somebody else about it. And people are starting to say, well, maybe I do identify with Amber Heard, or I do think that Amber didn't get a fair shake, right? And that's part of, I think, what I'm always thinking about when I try to design an outcome, like on a mediation or a resolution to a workplace dispute or a case. It's not just what people think in the moment. It's going to be what they think in 5 or 10 years. And I'm thinking about that. I don't want a client to come back to me in 5 or 10 years and say, I always kind of really felt not great about what we did there. I feel like I should have stood up for myself more. I feel like we should have gotten more, or whatever, right? That's what I don't want to hear. So often when we're in the midst of a proceeding, people will want to make settlements maybe that I'm saying I can't advise that because I know you're going to come back to me in 2 to 3 years and say exactly what I just said, right? That you're not happy with the outcome, even though today you can live with it.
It's almost like a strategy. You balance long-term thinking, long-term outcomes with short-term, in-the-moment tactics.
Yeah. And I think it's a combination of just being really, really prepared in advance, right? But also, like, something I probably should say to people, which I don't, is that when we're in the proceeding, your nervous system is going to be activated. You're going to be in fight or flight, and you're going to see the person that you've accused, and maybe you're going to have a huge emotional response.
That's a good one.
Yeah. Like, you're not necessarily in the right headspace to make good decisions. And that's why we set out what your agenda is well in advance. And we say, this is what we will accept. And we say, this is what we walk away from. If this is the resolution, we're not accepting it. We walk away from the table.
It's good though. I really like this thinking of deciding on your agenda way earlier, and every action that you take during the litigation, during the whole process, just works towards that agenda. No matter what it is, you've set your agenda and all your actions are contributing to that.
Yeah. And that's something I think you also really, again, need skilled lawyering for, is to keep people on task. And I've seen this in all kinds of ways that this plays out. Like, one thing that I've always had to manage if I go to a hearing with a client is they want to dispute every little thing. And they don't really recognize that there's no point in disputing a fact that isn't going to be juridically significant, in the sense, like, the fact isn't going to support a conclusion that's going to ultimately support the determination of the case. There's no point in spending time over it unless it's to attack the credibility of another witness or something like that. It really doesn't matter. And if we keep introducing noise into the proceeding, we're going to distract everybody, the parties and the trier of fact, from what's really important here. So I'm always trying to get people to focus on the outcome. Where are we landing? And does every single step move us there? Because it's really easy to get caught up in, like, tactics and not pay attention to strategy.
I love, love, love that. And I think there's a good phrase for this. Pick your battles, right?
Yeah.
Okay. So as we're ending, I would love if you could give some tips for aspiring lawyers or early law professionals in developing effective negotiation skills.
Awesome. Well, my number one tip, I know it's kind of corny after 20 years of doing this, is that you're never going to be effective in communications and difficult conversations with other people unless you can self-regulate. Okay. So that means that you have to really pay attention to your own emotional state and make sure that you're guarding that. It's really important because everybody around you will be in a flurry of anxiety, and they really need a non-anxious leader to guide them at this moment. So that's the advice I wish I'd gotten 20 years ago, and that's the advice I have now.
That's a great advice.
And I guess the other one would be just to, again, always look for ways to gather leverage. Don't fall into the pattern, like the cookie cutter pattern of expecting everything to go one way. And I think, again, the biggest thing that we can do to provide durable resolutions to disputes that people are going to be able to live with and move on from is recognizing that people are human beings and connecting with them on a human level, and really trying to design outcomes that, again, they may not be perfect, but people can live with them if they feel that they were treated fairly, if they feel that they were treated with respect. And sometimes that means that you acknowledge wrong or you acknowledge someone's suffering, right? And I think a lot of lawyers are really, really not prepared to do that because, again, they're just focused on liability. They're not focused on the human experience of dispute. And as a result, we end up with law pro claims, when people walk away from the table and then they say, oh, I settled for something that was not good enough and I'm going to make a claim on your insurance. That's my advice.
Juliana, this was an amazing conversation. I also love that we spoke about some modern day cases. Thank you for coming to my podcast.
Thank you so much for having me. It was so much fun to chat with you.
All right. I hope you took as much valuable information as I did and more. My name is Adele, and you have listened to an episode from 100 Sum Game. You like it here? Go ahead and subscribe to 100 Sum Game on your preferred platform. While you're at it, I'd love to hear about what you're thinking of this podcast, any episode requests, or further feedback. It'll help me make this podcast better for you. Thank you so much for tuning in, and I'll catch you in the next episode. Peace.